Hi guys, welcome back to my YouTube channel. For those of you who don't know me, I am Tebello Motswani. I am the founder of a platform called Sister-in-Law. I am an attorney by profession, and what most of you don't know is that I also run a legal consulting company called Collective Intelligence, and that's the company where I really try to provide legal services at an affordable rate for especially startups and growing businesses, because I do understand that at the beginning when people are putting their business ideas together, they don't always prioritize legal fees. And the importance of prioritizing legal fees only comes about when there's a dispute or litigation, and then you need the services of an attorney to unbundle the mess that you have made. So today I specifically want to speak about protection of your intellectual property. Now, intellectual property falls under 4 classes, namely a copyright, a trademark, a design, and a patent. Now, most of you might come to me and say, what is the first step that one should consider when especially wanting to pitch an idea to a prospective investor or to somebody who can take the idea to the next level? First and foremost, you want to ensure that you have an NDA or some sort of written undertaking concluded between you and the party you're presenting to that states that in the event that you don't end up using my idea, you won't end up using it for yourself. It's also going to protect you, the contents of whatever is being shared in that meeting, that pitch, to ensure that that person or that company does not steal your idea and use it as their own. Now, this obviously comes about as, I've learned on Twitter that there are allegations that Somizi stole the dinner with Somizi idea from up-and-coming entrepreneur or up-and-coming artist. And the person obviously is now in a bit of a crisis mode, learning that this is something that I've shared with this party before. They didn't seem interested in the idea, and now I'm seeing my idea on TV. What is my recourse? You should be able to prove, maybe through email correspondence or through WhatsApp correspondence, that the receiver did receive your idea. But if you didn't protect it, most of the time it becomes very difficult to prove that the idea is yours. So please don't underestimate the importance of having an NDA before you pitch an idea, making sure that there's some sort of undertaking that the person won't use your idea against you or won't benefit commercially from your idea, for example. But you also want to make sure that even if you do Google an NDA from Google, which a lot of people do, and it's very well, you want to make sure that you do have an attorney go over it with a legal eye, because sometimes on Google the market that they cater for is American and not necessarily the South African market. So you want to make sure that if it gets to dispute or litigation stage, that your NDA can at least stand and be enforced in South Africa. Now, like I said earlier, your intellectual property can be divided into 4 components. It's copyright, it's trademark, it's patent, and it is, what's the 4th one? A design. So trademark is the easiest one to sort of identify. That is basically, what idea can I give you? McDonald's or Coca-Cola. Everybody knows the font in which Coca-Cola is written. Everybody knows the colors, they're red and white. And same with McDonald's, everybody knows the golden M. Now that is what we call a trademark. Trademark is divided into 2 components. There's what we call a word mark, and then there's what we call a logo. The word mark would be the actual McDonald's or the actual Coca-Cola in just the normal Arial font, and all the way it's used in correspondence basically would be McDonald's. Then there's the logo component of it, and the logo is the famous M that we know, and for Coca-Cola specifically, it's that font that's used on Coca-Cola. So that is what a trademark is. It's either a word mark or a symbol which will distinguish your offering from the offering of your competitors. So your service or your product, it will be distinguished by your unique trademark. And that trademark, like I said, is a component of a word and a logo, or just a word mark or just a logo. But you do want to ensure that that is protected. Now you might ask, what's the purpose of registering a trademark? It's the same as being able to drive but not having a driver's license, for example. So if you get stopped by the cops, they can see that you've been driving this car, but where's the license that proves that you are a certified driver or a licensed driver, for example? And that's exactly what a trademark registration certificate will do for your brand. If your competitor starts using, a name very similar to yours, like Coca-Cola, for example, and they're also selling aerated cool drinks, you can then go and produce your registration certificate, which shows that you are the original owner of the name Coca-Cola, or whatever the case is. Then we have what is called a patent. The best way to describe or define a patent to you is that it will be very similar to an Uber. And the distinguishing feature about a patent is that it must be new. The invention must be new and must not exist anywhere else in the world. So I'm using Uber as an example because Uber was the first to patent e-hailing services, basically, or to patent e-hailing method. And then there was Taxify as the years progressed, and so forth and so forth. Uber owns that original patent. And so, for example, Taxify wouldn't be able to register that as a patent. But what Taxify can do is that if they modify the original patent, they can then register the modification as a patent. Now, both of these also fall under two intellectual property protection. It's first the patent, which is the method in which you use your Uber, you request the car, request the driver, so forth, through using an app. So that is what is protected. That idea was a new invention. That's what's protected. Then on top of that, Uber does have a trademark registered. So they've registered the name itself as a trademark, being a word mark, Uber, and then they've also registered their unique U. I don't know if you know their U. They've also registered that unique U as the logo to their trademark. So even without seeing the word Uber written and you see the U, you know it belongs to Uber. Even without seeing McDonald's written and you see the golden arches, you know that it's McDonald's. So that's an example of trademarks and patents. Then we have what we call a design. Design falls under two components as well. It must either be functional or aesthetically appealing. And the best way to highlight or define that kind of intellectual property is a blender, a smoothie blender. It's aesthetically appealing because you get the glass jar and you get the motor, and if your kitchen is green, you can buy a green Smeg appliance or whatever the case is. So that design, that unique Smeg design can be protected, and the functionality of the design can also be protected. The functionality is the fact that when you plug it in at the wall and you switch it on, the blades then turn and make a fruit juice or make a smoothie. That is a design. Then the last one, which I need to cover, which is the very popular one in South Africa, because everyone's always like, copyright your work, copyright your work. Yes, copyright your work, but 9 times out of 10, what people actually mean is that you must just protect your intellectual property, either through registering one of the 4 that I've mentioned, or a combination of some of the intellectual property protections. So the 4th and final one is what did I mention? I mentioned trademarks, design, copyright. So with copyright, it has to be, so you don't register a copyright. Unlike a design, a patent, and a trademark, you don't register a copyright unless it is for a movie. In as far as South Africa is concerned, unless it's for a movie. So a copyright is your idea. It can be a song, it can be a painting, it can be a poem, it can be a play, it can be a movie. The most important feature of a copyright is that it must be reduced to material form. What that means is that if you have a song and you present it to someone and you sing it and it's not recorded, and it's not written down on a piece of paper, it's going to be very difficult, in a few years' time to prove that, hey, this song of mine, I sang it to Tebello and now she's using it as her own. Yes, you may have sung it to me, but you didn't write it down. You didn't reduce it in material form. You didn't record it. So the importance of a copyright is that it must be reduced to material form if you want to protect it as a copyright. What I mean by that is that it will exist automatically. You don't have to go and register a trademark in the same way that register a copyright in the same way that you'd register a trademark. So it must be reduced to material form. Your painting, you can't describe it to me. You have to actually paint it, reduce it to a painting or on a canvas or whatever the case is. Your song, you must write it down. Your script for your movie, write that down as well. Your poem, write it down. As long as it's written down, that copyright applies, or that copyright is automatically attached to you. Now, we can then go into, at the beginning of the conversation, I mentioned that your intellectual property protection is an asset. It's an intangible asset, and it has value to you. It has value to your business. You can then grow your business by licensing your trademarks or licensing your intellectual property. And that is basically you giving another party consent to use your work in exchange for some sort of commercial gain. So licensing is a whole new topic that you also need to speak to an attorney about to assist you in working out your licensing agreements and so forth. But it is a manner in which you can give somebody else consent to use your trademark, to use your design, to use your patent, to use your copywritten work. So please make sure that you understand the differences of the 4 intellectual properties. Make sure that you don't underestimate the value and the importance of at least doing some research before going live with your idea, or before presenting it to somebody. And another thing that I just want to say to entrepreneurs is there is no use coming up with a great name, branding your products or branding your services, buying space to set up a salon, and then putting big signage, and then creating a website, and then creating bottled samples with the packaging with the name plastered all over, only to learn a year from now, after all those expenses, that name exists and it belongs to somebody else. This has happened too many times for me to even want to go into, but it happens more than you know. You may think that you've come up with a name and it was so creative and the chances of it existing are nil, but you do want to see an attorney about that name, to do at least a trademark search to ensure that the name is available for you to start using on your branding, on your websites, on your salon signage. Because all the money that goes into that, and then only finding out a year from now that you have to rebrand, it's definitely going to cost you more than the initial fees you paid an attorney to assist you with a trademark. So please, guys, do not underestimate the value or the importance of registering a trademark, or finding out more about patents, designs, and just protecting your intellectual property. It's very important. It's for your own benefit. It will, I promise you, save you money and heartache in the long run. So please, 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 you have to prioritize that. My email is at the bottom of the screen if you want to be in touch, and if you want to know more about trademarks, if you want to consult, and of course, if you want to protect your intellectual property. I hope you've learned something from today's episode, and I hope that a larger corporation or a Somizi won't catch you off guard.